Let's move, let's stay in the courts, but change tack a little bit. Advocate Charles Mnisi telling the High Court sitting in Pretoria that his client, accused number 3, is in pain and unable to give him any instructions. He raised concerns about accused number 3's condition, saying it makes it difficult to proceed with the case. This follows a directive from the area commissioner who ordered that no sponge protection under the handcuffs should be allowed for inmates. This is after an offender at Bavian Sport Prison escaped. Let's get the context now as to exactly what happened here. Linda Mnisi is with us to explain all of the above. Linda, good evening to you. Firstly, let's understand accused number 3's condition. Why was he in so much pain? What is the problem?
So, Oli, you'd know that the accused, when they come to court, they usually are in leg irons. And the issue here is that they were informed by the head of the BMAX facility at the Mampuru prison that there's a directive which was given which says that they need to remove the sponges from their leg irons, which basically shields them against the pain of the leg iron. And this follows, like you read in your intro, the escape of another prisoner at a different facility. This is now a directive that was given by an area manager, but this morning the court heard that Mthobisi Mncube, the alleged gunman, also known as accused number 3 in this matter, refused to come to court without those shielding pads on his leg irons. And what we know, or what the court was told, was that they then had to lift him up and bring him to court. You would have seen today, proceedings took a while to start. There was a delay, and because accused number 3 had not arrived in court.
Can I interrupt you?
Yeah.
What about the others?
So you'd recall that, the accused, Fisokuhle Ntuli, who's also accused number 5, is also kept in the very same facility. Right. He came to court, albeit with the same concerns that these, shielding pads had to be removed. But in the case of accused number 3, he then could not or did not want to come to court, saying that if he did not have those shields, then he would not come to court. I want us to take a listen to the head of the facility there, the head of the BMAX Center at the Mampuru prison, explaining to the court that directive.
My Lord, the instruction was from the area commissioner,
all right,
Mr. Kosa,
okay,
which we received on the 12th of July, right, 2025. And the instruction was based on the escape that took place at Bavian Sport,
okay,
where the offender had the sponge and the cuffs on top. The offender took out the sponge, and the cuffs could easily get out of the leg, and the offender hit the official with those cuffs, and he escaped. Up until today, he was never found. So we only got instruction from our area commissioner as Mampuru that we should not allow offenders to put in those sponges when they come to court.
All right, so the commissioner explaining this, and it sounds perfectly reasonable. This is a safety issue. The inmate who escaped has still not been found. And so, again, I ask you the question. I know you're going to throw to the bite of this accused lawyer. What makes him special? So the other, remember, it's 5 people accused here.
Yes.
So one person refuses to come to court because they don't have protection under the handcuffs. Were the others able to come to court without those sponges around these handcuffs? If your answer is yes, what makes number 3 special?
Well, the answer is yes. They were able to come to court without those shields. And, one of the accused, like I indicated, that accused number 5, Fisokuhle Ntuli, is also kept at the very same prison. He also complained about the same conditions, right, saying that, he was in pain. And largely that they shouldn't be punished for another inmate's escape this is a violation of, their human rights, and speaks directly to the issue of human rights that needs to be addressed. And because they are in so much pain, then accused number 3 then told, the court that he cannot continue with the trial. What is also interesting is that it seems his lawyer was so passionate that he also gave the court an ultimatum on this issue. Let's take a listen.
Yeah.
That accused number 3 is in pains.
He's what?
He is in pains. Yes. He is unable to concentrate. I'm unable to receive any instructions from him. If the court were to insist that despite this gross violation of a human right that has been subjected to, that this court says he can continue, I wish to inform the court, my lord, and with due respect, that I do not want to be seen to be part of that violation of a human rights, of the right of Mr. Mncube when attending this trial. Because he's not only been foot cuffed, he's also been handcuffed.
Linda, for the benefit of those who may not have watched the trial today, are you telling us that that's what the court was seized with the whole day today?
Absolutely. The proceedings started late and the court had to deal with this issue. The state arguing that this is really the cushions. The issue of the cushions is not something that is given by correctional services. It is something that the accused do for themselves. And now that this issue around safety and the risk of escaping using those cushions has arisen, it should be followed. It's a directive that should be followed. We had to adjourn, from that moment after those submissions were made, because from there, Advocate Charles Mnisi gave the court an ultimatum saying he would not be able to continue representing accused number 3 if the court were to order that they proceed under those circumstances. And we had to adjourn to see, because the suggestion was that we adjourn for the day, but the matter adjourned to see if there was a way in which this issue could be resolved. It adjourned until 2 p.m. At 2 p.m. we resumed, and the state then informed the court that a decision had now been taken from the highest level in correctional services that they be allowed to put those cushions back. And the concern from the defense was, until when? We need to know the duration, because the issue here is the violation of their rights. They're so disturbed that they can't concentrate. They're in pains. So what is the duration of this arrangement that was now made at the highest level of correctional services? And what the state said was that for the duration of the trial, they'll be then allowed to have those cushions. So the judge also wanting to know, so what do we do, or rather the state in fact saying, now that the issue has been dealt with, we want to proceed. We have 2 more witnesses that we want to call, but we're at the hands of the defense, because again, there was this issue that was raised around the accused being in pain. So are they able to continue? And the judge suggested, well, let's postpone for the day so that they can be able to address the issue of pain, and we continue tomorrow. So after recess, this is the first day, and the only thing that the court was able to deal with was this issue of the cushions or the shielding pads on the leg irons.
Wow, interesting indeed. And you wonder why then concerns are raised time and again about time wasting in court. Not saying that this was a time waster, but surely the court could have dealt with this in a much speedier way. But anyway, thank you very much, Linda Mnisi, our reporter covering that trial for us.